need to do what is called an answer. So now you're in defense mode, right? So we have, there's a template. It's not in the university, it's in the connoisseur program. It's called an answer to a lawsuit or something like that. It's inside of the connoisseur program. So an answer consists of one of three answers, right? You either admit, you either deny, or you lack sufficient information to admit, so you deny. Okay? It's not it's not you explaining, oh, I was sick, I was in a car accident. No, that's not what that period is for. The answer to a statement of claim is the simplest thing that a consumer will do in the process. And that can solve about 90% of the debt collection issue. So in the statement of claim, they might say, oh, the company name is LVNV Funding, and we bought the debt from Capital One, and something like that. I'm going to deny that statement because I don't know if that is true, right? I don't know, like they might say, defendant name is Daraine Delevante. He lives at 123 Main Street. Well, I'm going to admit that if that's my address, I'm going to admit that, yes. So I'm going to say, I admit. But if they're stated, like, don't assume anything. If they're going to say account number, asterisk, 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 123 belongs to Daraine, deny. I lack sufficient evidence to admit to the fact. So it's answering their claim, and each statement of claim must be answered. If there's 10, you can't answer 5 and then leave 5. You got to answer all of them.
So I guess I was thinking if they actually have you to the point where you actually go to court, the word I was looking for is since they have you there already, would you not do a counterclaim at that time for damages?
Well, you could, but you got to think about defending yourself first before you want to go there. Okay. Because remember, if they're coming after you, you have to defend yourself. And how you're going to defend yourself is, did they follow FDCPA laws? Is the account past the statute of limitation? Do they have legal right to even collect? Was there an assignment of contract? Was there proof of the purchase? Did they do all the validation notice? They were attempting to collect and they still did not validate the alleged debt. And all debt collection activities stop once the consumer starts or initiates the validation process. Once the validation process is in place, all debt collection activities must stop, which include the reporting of the account to any consumer reporting agencies or any action being taken, which in this case would be a lawsuit or arbitration or whatever.
Okay, cool. All righty. I have a client that received a notice. It's Locke's Legal Group. It says Locke's Legal Group LLP is a law firm which may be deemed a debt collector for Ali Financial, right? Ali Financial, as a server for Ali Bank, referred your account, and then whatever for legal proceedings. How would you respond to that?
Did they send the client a dawning letter for them to verify the alleged debt?
No, pretty sure they did. He got this, and this is what they sent to me. So probably the answer is going to be no.
So in that case, I would send out a notice for validations of debt.
Okay, that's what I thought. Okay.
Because if they haven't, did they file a summons? Did they file a statement of claim yet?
No, this is the first letter he got.
Summons?
No, this is the first letter he got.
Okay, so in that case, I would, what you want to find out is, are they collecting on behalf as an assignee of Ally Financial, or did they buy the debt? Like you want to, because if they're an assignee, your approach is going to be different than if they bought the debt and then they're attempting to collect. It's like two different approaches. You know what I'm saying? Because if they're an assignee, they're collecting on behalf of. But if they're a debt buyer and they bought it, then my volunteer non-fit injurer will stand. So I need to know if there's a purchase agreement. Did they purchase the debt? Like these are the type of things that you wanna know. So in your validation information, it requires these things.
Okay. All right. Gotcha. Thank you.
You're absolutely welcome. Back to you, Shante.
Thank you, Win. Okay. Caroline Smith, you're up next. How are you?
I'm
Caroline.
fine. Hey, Daraine.
How you doing?
I have a question.
Talk to
Someone
me.
called me today because her state refund, I'm in Ohio.
Mm-hmm.
Her state refund was offset. She just filed her taxes last week, and she had a refund due her from the state of Ohio.
Mm-hmm.
And she received a letter from them stating that they were offsetting her refund for a tax debt that they allege she owed them from 1998. That's 26 years ago.
What? So
now, I looked up the statute of limitations says for any debt is 6 years, but I've specifically put in for income tax debt, and it said 7 years.
Well, it wouldn't be income tax. You said tax lien.
No, it's not a lien. They offset it for, they said that she owed some taxes in 1998.
Okay. So I would fight that. So you're saying that for the statute of limitation for income tax is what? 7 years?
That's what it says when I looked it up.
All right, look at the state. You want to find your state.gov website and find that. Just make sure you find it on a state website. If you do that, then you can challenge it under statute of limitation.
Okay.
But don't get it from like a third-party website. You want to get it from an official website.
Okay.
And then
but still, 1998, that's from 1990, 26 years ago.
I mean,
that's bullcrap. And the state of Ohio, they have like 3 debt collectors that they use to collect debt from them. And I prepared her taxes for her for several years. And now they're just now coming up with saying that she owed some money from 1998. Don't make sense.
So did she send over the letter to you? Did you get a read of the letter?
I have a copy. She sent me a copy of it. I've got it with me right now.
All right. So the important thing is you want to read through it and see what their claims are. Then now comes your research. Okay. You did your research and you found out that the statute of limitation for that particular state, and I'm going to assume that your client is a resident of that state, right?
Yes.
Is 7 years. So all you need to do now is just build a statute of limitation letter. So look in the university, we have a statute of limitation letter. All you need to do is modify it for the tax purposes, get it notarized, and send it to the IRS.
Okay, or it's actually the state of Ohio.
Yeah, so you would send it to the state of Ohio. You would do that.
Okay. All right.
And then see what their response will be.
Okay.
Can I say something, Daraine, real quick? You know that I'm a tax
I got 5 minutes left, and I got 2 more questions.
I'm just going to say something to Caroline. Caroline, this is it. You have to go to the. I'm going to write to you in the chat so that you can see what you have to do. Okay.
Okay. Thank you.
Yeah, we'll take that offline, but that would be my approach to it.
Okay.
All right, cool. Thank you very much, Caroline. Britt, who do we got next?
Perfect. Yep. And just for future references, if anybody does have any suggestions, thank you for all the help. Just DM them directly, just so they can just get their information faster. Up next, we have Kenny White. It's over to you. How are you?
Oh, very well. Thank you. Can you guys hear me okay?
It's a little bit choppy, but we can make you work. What you got, Kenny?
I'm sorry about that, Coach. I'm on the road here. Yeah, so the other night I was actually watching your live that you did with child support is fraud. And you were basically discussing the usury laws. And I had a client who hit me up, and he basically had an auto loan in the state of Georgia, and they actually exceeded the maximum amount of interest that they could charge him. They were actually charging him 16.98 16.98% for 75 months. So I'm just to make sure that I'm attacking this the correct way is the first step would obviously be to send the usury law letter. That's correct.
Mm-hmm. That would be your round
Okay,
one
then-
letter, yeah. Just make sure you
Okay.
include all the facts. Like including the facts will be simply you identifying when this contract came to fruition, when your client made the payments, how many payments they made, and if you can do the calculation, you can take it a step further and let them know what the excess has been paid over that period of time, and then the sum total of it, and then now you're requesting one. If the account is still open and there's still a line of credit where there's payments being made, it can be credited back to the account. But if the account is paid off and it's closed, then we're talking about them reimbursing and sending a check.
Yeah, I was actually just looking at it. He paid off the loan, but it's showing that it's still open on his Experian report. So.
Well, if it's still open, there's a few things you can do. I wouldn't mess with it just because I just want people I just want violations. Like that's why, right? So if it's paid off and I have proof that the account's paid off, so let's say now it's open and then they go report a late payment on a closed account that's already paid off. You know that's a S2 violation. Right?
Sure.
So like knowing what I know now, I welcome all the negatives because they like everything you can think of, there's a law specifically for it.